Your phone buzzes at 2 in the morning. The hospital says the other parent is in the ER after an overdose. Or you open a note from school saying they're seeing worrying behavior tied to a new diagnosis. Your stomach drops. Suddenly, it's custody, school safety, and 1,000 questions before you've even made coffee. Welcome to Danny's Den, your weekly mix of law, love, sports, and pop culture. Let's chat. Today, I want to walk you through what actually happens in family court when mental health or substance issues come up, and give you clear, practical steps you can use tonight.
Quick promise. In about 10 minutes, you'll get 3 legal realities to understand: immediate safety steps, a short how-to for documenting progress, and simple routine ideas, sports rituals, and a music trick that help both your child and your case.
Here's the legal reality in plain language. Judges are not out to punish parents. They want safety and stability for the child. So what do they ask? Is the child in present danger? Is there a pattern or ongoing risk? And importantly, is the parent actively engaging in treatment and responsible behavior? Those 3 questions drive decisions in family court.
Look, a criminal record can matter. But in family court, medical and treatment records often matter more because they show what someone is doing now. Judges respond to steady steps: therapy attendance, medication compliance when appropriate, verified program participation. Past mistakes are one piece of the puzzle. Current progress can change the picture.
If there is immediate danger, threats of harm, suicidal behavior, or a child at risk, call emergency services right now. I'll wait. After safety, get legal help. If a lawyer isn't available, local hotlines and legal aid can guide emergency filings.
But what about tonight? What can you actually do when everything feels chaotic? Start small and concrete.
Step 1. Write down what happened. Dates, times, exact words, who was there. Keep it factual. Emotion belongs in your support network, not the timeline you'll share in court. Step 2. Get records. ER intake forms, treatment intake notes, police reports. Take screenshots of messages and save voicemails. Originals matter, but copies organized by date are gold.
Step 3. If exchanges feel unsafe, suggest supervised exchanges or a neutral public drop-off while you arrange help. That shows you're prioritizing safety instead of escalating conflict.
A quick real example. A parent I worked with kept a simple attendance log: therapy visits, AA meetings, check-ins at the sober living house. After 6 weeks, the judge allowed expanded visits because those logs showed consistent effort. Small records can lead to real changes. Now, building a treatment and parenting plan that judges respect, think consistency. Regular therapy, verified program attendance, following medical plans when prescribed, parenting classes when recommended, and stable housing or sober living when applicable. If the parent commits to study attendance and you can show that with dates and sign-ins, courts are much more likely to prefer gradual reunification over cutting contact off entirely. The goal most judges have is reunification when it is safe, not punishment. Evidence you should collect: medical and treatment notes, intake and discharge forms, attendance logs for counseling or support groups, pharmacy refill records, school reports, attendance, behavior notes, counselor observations, and short witness statements from relatives, coaches, or babysitters who can describe the parent-child interaction.
Organize these by date, keep originals safe, and make a 1-page index so your lawyer and a judge can read the arc of change quickly. It matters more than you think.
Let's talk about routine, because routine is something judges notice and kids need. Predictability matters. Keep game day rituals if that's your family. Eagles Sunday, Yankees afternoons, pancakes before the match. Whatever the ritual is, keep it consistent, even if someone else steps in to help. Music helps too. Pick a short, calming 3-song playlist for bedtime. Make a morning song that means we're starting the day. That shared soundtrack becomes an emotional anchor, and over time, shows routine in testimony or photos.
Wait,
What if the other parent refuses treatment? What if they won't enroll or they flat out refuse supervised exchanges? You still document. You still propose supervised arrangements. And you bring counsel. A lawyer can file motions pointing to lack of engagement while proposing a path forward, treatment plus monitored parenting time, rather than an all-or-nothing fight. A few misconceptions busted quickly. Asking for help is not admitting you're unfit. A past substance problem isn't an automatic loss of rights, and involving child services can mean connection to treatment and supports, not immediate separation. Transparency plus action is the smart play.
When to call a lawyer? As soon as parenting time is threatened, hospitalization, arrest, or a hostile petition from the other parent. If money's tight, check legal aid, law school clinics, or sliding scale attorneys. Many places offer emergency consults at low or no cost. Before we wrap, 3 quick takeaways. 1. Safety first. Call emergency services if there's immediate danger. 2. Document and enroll in treatment. Steady attendance matters. 3. Preserve predictable routines. Sports, playlists, and small rituals show stability. One small task for tonight? Pick one routine you can lock in for the week. A 5-minute bedtime playlist, a Sunday walk, or a consistent pickup plan. And write it down. That tiny promise becomes evidence over time. Music pick, try 3 Little Birds for a short, steady reset. Add it to a calming playlist, or use it as your post-school decompression song. It's simple and steady, and it helps create the emotional routine you want for your child. If this episode helped, subscribe so future Court Smart conversations drop into your feed. Quick reminder, this episode is general information, not a substitute for legal or medical advice. For specific legal help, send a direct message or email me at danielle@thelegalassistantcenter.net to book a free 30-minute consultation. If there is immediate danger, contact emergency services or your local crisis hotline now. Thanks for listening to Danny's Den. Keep that small routine promise this week. Document one thing and let music be your ally. Let's chat.